All right, well, welcome everybody. We are thrilled to have you here today for our legal webinar. I'm Megan Denhart. I am with CalSAE, and I'm just going to try to hide my meeting controls here so you don't see that black box everywhere. So thank you so much to Novi AMS for this being a wonderful and generous supportive sponsor of today's webinar. Here to say a few words on behalf of Novi AMS is Jen Norman. Jen.
Hi, everybody. Good morning. Well, good morning on the West Coast. I'm coming to you from Tampa on the East Coast. So good afternoon here. It's good to see some faces that I saw at Elevate last week. So hello, hi, Amanda. I will keep this very brief. We are Novi AMS Association Management Software and proud partners with CalSAE. And to kind of serve all of your association management software needs. So I'll drop a link to our calendar should you be interested in having an informal discovery call with us. We'd love to chat. But otherwise, we are excited to sponsor today's webinar. And I also get to introduce our speakers for today. So we have two speakers. First, we have Dorothy Dang. She's a partner with Whiteford Taylor and Preston LLC and is a member of the firm's association's nonprofit and political organizations practice group. Dorothy has over 14 years of experience in assisting nonprofit associations on a variety of legal issues, including governance, intellectual property, social media, privacy, dispute resolution, and international operations. Dorothy also served on ASAE's International Associations Advisory Council and Technology Professionals Advisory Council. That's a mouthful and a lot to say, but I think I got that in. So that's Dorothy. And then we also have Kevin Serafino, Esquire today. He's an associate with Tenenbaum Law Group. I think a lot of you probably know that group as well. Kevin has extensive experience advising nonprofit organizations, including public charities, private foundations, trade and professional associations, and social welfare organizations on a broad range of legal issues. He also leverages his decades of experience working in-house at two national trade associations to provide practical and actionable legal advice to mission-driven organizations. So thank you both, Dorothy and Kevin, for being here today and lending some of your expertise. I will turn it over to you. The virtual stage is all yours.
Next slide. Thank you for the introduction. I am Dorothy Dang, and of course, starting from a disclaimer, this webinar is provided for educational purpose only. The views expressed by Kevin and I are a lot of our own personal observation and comments. If you need more specific advice, please consult with your attorneys or a legal expert. Next slide. So we are very happy today to go over really two landmark Supreme Court cases that was issued in 2023 that has created a lot of litigation in this realm. For our association clients, it is also very dear and near to many of our association clients' heart, because associations are mission-based entities that bring people together. And sometimes through gender, sexual orientation, religious belief, race, and ethnicity. It is just part of the nature of many of our association, the association community. So this has been a hot topic for many of our clients. The DE&I initiatives issue and affirmative action, and also expressive speech as a nonprofit 501c3 or 501c6 or any exempt organization. So today we're going to the first part of the presentation. I will be focusing on the Students for Fair Admission versus Harvard College and University of North Carolina case, which is known as the affirmative action ruling, recent ruling. And Kevin will be more focused on the 303 creative case that focuses on First Amendment. There is going to be an overlap in these two cases in one of the primary feature case that we will get into. So this is just a teaser of our presentation, but we will be covering both cases today. Next slide. So I would like to go over briefly just to level the the field a little bit about the Student for Fair Admission Supreme Court ruling. So to talk about Harvard's actual admission process and sort of keep this in the back of your mind when you consider your own program and try to see sort of the similarities and things that we will be getting into. So again, this is more of a preliminary slide. So for Harvard's admission process, the critical bullet points here is the first one. At the final stage, when the committee determines who will be coming into the freshman class at Harvard, there's only 4 pieces of information available: legacy status, athlete status, financial aid eligibility, and race. And also notice, you will be hearing this a lot, especially because we are mission-driven organization. So it's going to tie back to this. What is Harvard's goal? Harvard's goal is to make sure that Harvard does not have a dramatic drop-off in minority admissions from the prior class. So this is the basis of the Harvard case, sort of the critical facts that's relevant to the presentation. And the lawsuit was filed by this, also a nonprofit organization, a membership association. They filed the lawsuit challenging that race plus admission, AKA affirmative action, violates Title VI of the Civil Rights Act and the Equal Protection Clause of the 14th Amendment. Next slide. So let's get into the legal test. So the legal test that the Supreme Court applied, and you will be, and it's being applied in all of the ongoing litigation, is the strict scrutiny test. And I want to make a note that the Supreme Court in the prior ruling, and it is actually okay to treat people differently. It is legally permissible to have programs that arguably discriminate or treat people differently based on different categories, provided that it passed strict scrutiny. So I think I want to make that point clear. That is, you can have programs such as prior affirmative action. Now it's severely limited after the Harvard case, but for a very long time, affirmative action, which is to use race as a plus factor in college admission, has been permissible because of which is now overturned by the new case. But to remember that it is okay under limited circumstance, provided that we pass strict scrutiny. So what is this? So this is an analysis for the Equal Protection Clause in the Constitution. So if there's any exception to equal protection, there is a 2-step analysis that must be conducted by the court. Step 1, whether or not the racial classification in the Harvard situation is used to, quote, further a compelling governmental interest. So is there a compelling interest? Number 2 is, if there is a compelling interest, whether or not the use of race is narrowly tailored, meaning necessary to achieve the interest. Next slide. So in the Supreme Court's ruling, ultimately, the Supreme Court determined that without really discussing much about the compelling interest, the majority ruling said the admission program, affirmative action, failed the narrowly tailored test because of summarized 4 reasons. First one is lack measurable objective warranting use of race. Second one is employing race in a negative manner. And in this case, there are fewer Asians and white students being admitted to the freshman class. The third one is the affirmative action involves racial stereotyping. That means there's an assumption that just because you are a minority, therefore you always have a certain, quote, minority viewpoint. For example, just because I'm Asian, therefore I must represent some kind of Asian viewpoint. The Supreme Court said that is racial stereotyping. The fourth reason is lack of meaningful endpoints. Another critical point in the majority's ruling, and you will be hearing it a lot, is there is a clarification that specifically said, and I have it in red here, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. Because of this, many of you may know that the higher education community, what they've been doing is to use the college essay or personal statement component of the application to instruct people to potentially discuss race or other identity about how that identity inspired them or led to discrimination otherwise, right? This is quoted from the majority's ruling. So, and I also want to make 2 points in terms of the ongoing litigation. The 2 elements, in my opinion, that is most relevant is the second one and the third one. The second one is employing race in a negative manner. So for a lot of the program, and most of the program being challenged in the ongoing litigation is when not only employing race in a negative manner, that fewer Asian whites are admitted, is when your program would exclude people in certain racial category entirely. That would be problematic. The third one, the second point, which is the third point here, is racial stereotyping. So this is relevant in terms to how people view what the word DEI or diversity means. So anytime there's some kind of racial stereotyping, meaning we must admit more Black, Latino, Asian, LGBT people just because we believe they must bring a specific Black view, Asian view, or LGBT view to the community. That assumption on its own, just because that is considered stereotyping, and that could be problematic. Next slide. So what happens afterwards? Shortly after the Supreme Court handed down the Student for Fair Admission ruling, another organization founded by the same founder, Ed Blum, American Alliance for Equal Rights, AAER, filed several lawsuits based on violation of Section 1981 of the Civil Rights Act of 1988. The setup for AAER is very similar to Students for Fair Admission. So they follow the same pattern, very organized and strategic way. And he is certainly a crusader that he said he will not stop, right, until it's, quote, equal rights for all. So that is his viewpoint. So there are members of AAER who are ready and able to apply for the various programs that are being challenged. For Section 1981, which has been the primary focus for a while now, the statutory language says all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts as it is enjoyed by white citizens. The legal focus is make and enforce contracts. So that's the focus for that is most relevant to a lot of our association clients. So the first wave of targeted programs are prominent law firms, D&I fellowship and internship programs. Next slide. So this is the first wave of legal challenge that AAER pursued against the law firms. All of these cases settled, and I wanted to use this slide to sort of to demonstrate the before and after, because it really is going to speak to what I think is going to happen next, and it also reflects the Supreme Court's ruling that we just went over. So on the left-hand side, there is a pattern that using race or minority groups or historically underrepresented group as part of the eligibility requirement. That is the programs that are challenged. Another one that to me that was very kind of jumped out to me is look at how lucrative, not lucrative, but look at the compensation we're talking about here. And these are short-term employment contracts, right? Fellowships and internships. These are summer associate programs at prominent law firms. In addition to the compensation they receive as summer associates working at these prominent law firms, they are receiving 5-figure stipends and potentially a spot in their first-year associate class. And some of these starting salary is $200,000. So there's a lot at stake in terms of financial incentives. And there are racial categories and other categories set up that would exclude mostly white and male applicants. So that's on the left side. On the right side is the revised eligibility criteria. And I sort of group them into 2 categories. One category is the top one, which says anybody, regardless of whatever category, now you're eligible to apply. So that's one kind of way to responding to the challenge. The second one, which is in the middle one and the bottom one, is more of a revision to what the law firms here consider to be diversity, and rephrasing it to use words that, culture fluency, life experiences, individual perspective, your own unique perspective. So it's a little bit more similar to the college essay clarification. So that's another trend that I've seen in terms of rethinking how to still have a good diversity program, but modifying it. And so in this case, all of these cases settled pretty quickly after the lawsuits were filed. Next slide. And then AAER, they did not stop. They continue to pick on different sectors and different organizations to challenge their DE&I initiative. Hidden Star, you will notice that this case settled in 20 days. And this is a 501c3 nonprofit organization. They have a Galaxy Grant program, and they require contestants to be a confirmable ethnic minority or female. So that is the eligibility requirement. They got sued, settled in 20 days, quickly changed their selection criteria to we are just going to use a random selection device to pick who gets the grant, right? This is, I don't know how I feel about it. Again, they avoided a lawsuit in 20 days, but instead of looking at people's application, they're using a random selection device, right? So that is moving very quickly. And then also removing from the FAQ that this is only for minority and women-owned businesses. Another new lawsuit filed by AAER, also based on Section 1981, is Founders First Community Development Corporation. So this is a new case. I was curious before this presentation and looked up the docket. So there's still not any substantive response. So this is very, very recent, but they are not stopping. Next slide. Now, everything that I just presented above, they all settled, right? There's no case law, no precedent, no court ruling, everything settled after revision of their DEI programs eligibility criteria. Now, this case is active and ongoing, and I am closely watching and Googling the status and looking at the docket pretty much every other day, if not every day, right? So this is directly relevant to almost all of our exempt organization, 501c3, 501c6, association and nonprofit clients, because the primary defendant in this case is Fearless Foundation, even though most of the news coverage would characterize this case as the Fearless Fund venture capital firm, but the primary defendant is the 501c3 foundation who administered the program being challenged. The program being challenged is called the Fearless Strives Grant Contest. Only Black women-owned businesses are eligible to participate. The winner receives $20,000 grant and mentorship opportunities. The issue relevant to our nonprofit clients are really two. Number one, whether or not a grant contest such as the Fearless Strive Grant Contest constitute a contractual agreement that puts the entire legal ground within Section 1981. That is the first issue. Is this a contract? Number two is whether or not the First Amendment would bar the plaintiff's claim. So this is a free speech issue. So this is when we cross over to the second part of our presentation, which is the Creative 303 case. Next slide. So what are the legal issues presented in the Fearless Fund lawsuit? I said there are two, right? One is whether or not this is contract, and it's really related because the plaintiff in this case says the grant contest is a contract, because if you want to apply, if you want to participate, you must agree to the official rules, the terms and conditions, how to enter and what is the judging criteria. And you also need to give permission to, for the Fearless Foundation to use your likeness. And as we all know here, we do this all the time, right? I look at these type of official rules and terms and conditions to enter into some kind of contest or competition all the time, because that's what we do. So whether or not it forms a contract, well, in this case, it's, well, is this a contract or is it not? Fearless Foundation says this is not a contract. It is a discretionary charitable gift. Therefore, we as a 501c3 foundation with our mission, we have a First Amendment right to free speech and express and promote our view to promote Black women-owned businesses. And that is according to 303 Creatives. So next slide. So the final bullet point is really a simple way to say there's a lot of litigation going on. There's been a lot of briefs and there's multiple amicus briefs filed by different type of nonprofit organizations. The oral argument concluded, I think, late January. It is literally every day we can receive a ruling from the 11th Circuit on the issue. And my speculation is, regardless of how the 11th Circuit Court's going to rule, it's probably not going to stop here. It's possible it could stop, but my sense is this could be one of those cases that moves slowly in the court system, that we eventually will see some type of clear ruling. I don't know. We don't know. We're watching. But really, the takeaway is, at what point does a program cross over from a true charitable gift that is protected by, you have a First Amendment right to free speech? At what point does it cross over to a contract? Because when you have too many strings attached to a gift, it's no longer a true gift and therefore a contract. We all saw from those the law firm cases where we're talking about internship programs or fellowship programs that are really truly short-term employment. Those are based on the contractual basis. So my view is, if we're talking about a very clear contractual relationship, such as a short-term employment contract, you're more on the vulnerable end. However, if your programming is more like a gift, then arguably, and we don't know, we're watching the court's decision, is it may be more in line with a charitable gift and supporting your mission purpose. Next slide. And I want to go over quickly, still, I said earlier, plaintiff groups like AAER, they're not going to stop, and they have not stopped. This is more known as the Smithsonian Museum case, filed very recently. You can see on the third bullet point, this settled in about a month. The program being challenged is their undergraduate internship program at the National Museum of the American Latino. So, of course, part of the program originally says this internship program is designed to create hands-on training opportunities for Latinos, right? As the name of the museum suggests. But after the lawsuit was filed and in about a month, the museum decided to change the criteria and clarify that now the internship is equally open to students of all races and ethnicities. The reviewer should not give preference or restrict selection based on race or ethnicity. So this is a settlement, no case law yet. One thing to note is instead of a Section 1981 legal basis that we were talking about, this case is using the Fifth Amendment Equal Protection Clause that binds the US government. So next slide. So we can see there is a trend of testing other statutes and testing other organizations' program. Okay, so enough about the AAER. Let's talk about other lawsuits that relates to following the affirmative action ruling. This is a case, and this is actually an association. It's the Wisconsin Bar Association, that their members are attorneys that are licensed to practice in the state of Wisconsin. The plaintiff challenged the Bar Association's diversity clerkship program. And the challenge is that the plaintiff is upset that his membership dues, he feels that it's compelled, he is being compelled to pay membership dues to support a program that he disagrees with. So he sued the association. To me, the interesting part, again, this case also settled, so no case law whatsoever. It is a settlement. I think the interesting observation from me is the settlement redefines what diversity means for purpose of the diversity clerkship program. So diversity means it's including people with different characteristics, beliefs, experiences, interests, and viewpoints. So that is one of the takeaway is how do we define diversity? And you can see the categories, the racial categories, gender, sexual orientation is not to be seen in this redefined diversity definition. Yet the diversity clerkship program still stands. Next slide. And this is also the Ultima case. This is not for association, but I just want to show the audience a trend here. So Ultima Services versus Department of Agriculture. This lawsuit challenges a program that is called the 8A certification program administered by the U.S. Small Business Administration. So this is a business development mentorship type program that supposedly helps historically disadvantaged groups. So for a very long time, there are certain categories that the SBA considered to be presumed a disadvantage. That would include minority-owned businesses and women-owned businesses and veterans, I think. There may be another category. Again, I'm not a government contract attorney, but it is a presumed disadvantage. It's a presumption. After the Supreme Court ruling, the court in this case said, well, you have to enjoin. There's an injunction that prohibits the SBA to use this practice, a presumed disadvantage. So the SBA has since revised the program now to require a social disadvantage narrative. So this is mimicking the Supreme Court's college essay clarification that there is a narrative or personal statement or college essay that the applicants can discuss race and other categories and how they are disadvantaged. But instead of checking a box that I am a woman-owned business or minority-owned business, and therefore I'm disadvantaged. Next slide. So I want to summarize this component of the presentation about some of the takeaways. And I think we already mentioned that plaintiff groups such as AAER, they are going to be identifying different sectors. They're going to be identifying different programs they are identifying who's their next target. And in addition to that, they're going to be testing different statutes in addition to 1981. So they are not going to stop. These challenges will be continuing. And my observation is they are rather strategic in identifying their targets. So that is one of the takeaways. And another takeaway is in terms of DEI programs, generally speaking, if there's some kind of eligibility requirement that is based on racial categories, but that can also extend to gender and sexual orientation as well, and even religious categories. But if it's the most vulnerable is if there's a racial category, you are vulnerable to legal challenge if you exclude other categories. And I also want to add, and also if you don't have a good compelling interest. So don't forget that the strict scrutiny is a two-step analysis. And always keep in mind that it is okay to have different treatment as long as you pass strict scrutiny. So at least that's a legal analysis, right? So there's always a two-step analysis. Step number one is, do you have a compelling interest? And number two is it narrowly tailored? And the narrowly tailored is there any racial stereotyping, and are you excluding other people? But when I am looking at a lot of our clients' DE&I related programming, I think one of the things to rethink is, what is our compelling interest? What is our mission purpose? How do we tie it to the mission that we wish to promote? And I think Kevin is going to get into that even more, but to rethink about what do we want to achieve instead of just copying and pasting a lot of the things that we've seen out there, right? How do we, what is the, and I want to bring it back to the Harvard's objective. Harvard's objective is they do not want a dramatic drop off of the prior minority admission, a minority student's admission. Even though the Supreme Court didn't really get into that part, my view is that probably was not good enough of a compelling interest. But I also want to make a point that in terms of the prior affirmative action case, which is Grutter, the compelling interest is campus diversity. Campus diversity remains a legitimate compelling interest. But really the question is becoming, well, what is diversity? So how do we define diversity? So that's just one of the takeaways that I want to make here is there's always your compelling interest, which is related to your mission purpose, related to what your organization strives to. And diversity remains a compelling one. It's just how we view diversity that may need to be reimagined or rethinked or recharacterized. Next slide. And I will turn this over to Kevin right now.
Thanks so much, Dorothy, and good morning, everyone. Thanks for allowing me to be here to chat with you all today. Again, like Dorothy mentioned, this is a topic that a lot of our clients have been increasingly focused on. Again, I'm Kevin Serafino. I'm an associate with Tenenbaum Law Group. We serve as outside general counsel to lots of trade associations, professional societies, and other nonprofits. Like Dorothy said, a lot of clients have these They're seeing internal challenges to some of their DEI programs, and they're trying to prevent them from turning into external challenges, something that is in court or a lawsuit being brought by an outside group. So this issue is very relevant. But I'm going to focus on a slightly different aspect of the diversity, equity, and inclusion conversation. And that's going to be focusing a little bit more on governance and how, separate from the programs and I guess the contracts that Dorothy was addressing, I'm going to be talking a little bit more about governance and membership programs and making sure that your governance it can be used as a tool to advance inclusion, even though some of the programs are coming under attack. So I just wanted to do a bit of a level set here. Now, following on these affirmative action cases, a lot of you may remember last year, the Supreme Court had a chock-full docket with very closely watched cases. The students for fair admissions cases were decided on June 29th. And on the very next day, next slide, please, we got 303 Creative versus Elenis, which is a case that I think a lot of folks who are, keeping a close eye on DEI related court cases, this one was pretty discouraging, right? Next slide, please. So the upshot was that there was a website designer in Colorado who did websites for couples who were getting married, and the website designer wanted to refuse to serve same-sex couples because they claimed that it would be their speech in creating a website, and it would be compelling speech against their religious beliefs. This was in conflict with a Colorado law, the Colorado Anti-Discrimination Act, which prohibits discrimination in the realm of public accommodations. And it specifically cited sexual orientation as a protected class. But where it started to get a little difficult, where the court was grappling with this, is that the public accommodations law was very broad. And it really came to include anyone who's offering us a good or service to the public. So, traditionally we think of public accommodations being restaurants and hotels and transportation providers. But public accommodations laws in the states have expanded over many years to really include pretty much anyone holding themselves out to do business. And there was also a previous challenge to the Colorado Anti-Discrimination Act. A lot of you may remember the Masterpiece Cake Shop case, which was another LGBTQ rights case that was very closely watched. And it was really punted on procedural grounds. I think the ideological folks would have said that it was a win for the religious community and kind of gaining an opportunity to discriminate or achieve some religious freedom, depending on which way you come at it from. But it was really a procedural ruling. This 303 Creative case was an effort to distill it a little bit more and kind of dispose of some of the procedural elements that plagued the Masterpiece Cake Shop case. So again, website designer who wants to refuse to serve same-sex couples in creating wedding websites. Next slide, please. So the holding was really that we're getting back to Dorothy's description of the strict scrutiny test, which applies in First Amendment cases as well. Here we're talking, balancing the state's compelling interest in preventing discrimination, but on the other hand, we're trying to uphold First Amendment rights in what is deemed an expressive activity. The website design was considered an expressive activity. This is actually something that was not up for debate in this case. The parties at the lower court level had stipulated, they had agreed that creating the website was an expressive activity for the website designer. Even if there were a lot of arguments that it is not her own speech, it is, the married couple's speech, but they stipulated at the lower court level that the website design is expressive activity that is deserving of First Amendment protection. So where the court came down is really saying that yes, it's a compelling interest to eliminate discrimination, but the public accommodation law is so broad that it can't be narrowly tailored to achieve that interest. So again, that's the same kind of a strict scrutiny test that Dorothy was talking about earlier. The place where this comes in for nonprofits and associations is that the court relied on a really key case on expressive association that came up in the year 2000. Boy Scouts of America versus Dale. And this was the key precedent the court relied on in 303 Creative. So in Boy Scouts of America, the Scouts revoked the membership of a gay Scout leader, an adult Scout leader, because he was openly gay. The Scout leader sued the Boy Scouts under the New Jersey Public Accommodations Law, which was structured similar to Colorado's and prevented discrimination based on sexual orientation in public accommodations. The Scouts said that their defense was that they have an expressive association, that being a member of the association is a form of expression that is protected, and that the organization itself is free to express those beliefs, and that admitting a member that is inconsistent with those beliefs is a violation of that free expression. So again, it's kind of taking membership in an association and the association's statements about itself and its values and what it hopes to achieve. That is also protected under the First Amendment. And that's exactly what the holding is. The court said that forcing the Boy Scouts to admit a member who has conduct that is contrary to their beliefs. And, if you go into the case, you see, a lot of people are familiar with the Boy Scout oath, to be, morally straight and clean and thrifty and cheerful and all these things. The court is saying that the expressive association that the Boy Scouts had, sorry, next slide, Megan. The expressive association that the Boy Scouts had was based on, they are inculcating their members with a certain value system. The court also said, and this is very important, that the First Amendment does not require that every member of a group agree on every issue in order for the group's policy to be considered expressive association. So a group can have and communicate its set of values and what it stands for and what it strives to uphold. And different members can disagree on that, or they can fail to uphold certain segments of it. But as an organization, they get to decide who's a member and who's not. So rightfully so, these decisions are viewed as working against inclusion, right? In both cases, these were cases involving the exclusion of people in the LGBTQ community. But the language underlying Boy Scouts of America versus Dale is an incredibly powerful tool for association governance, because it gives the associations a very powerful shield against claims related to their admissions of members, related to their governance, and really allows them to set the course of their membership and governance because it is protected as First Amendment expressive association. Again, this is a very, very powerful statute, or sorry, not case for the association community. Next slide, please. So how does this get applied in other contexts? There's been a very recent case that is, I think, a very good illustration of how this is applied in other diversity contexts, but with other kinds of membership associations. And that case that I wanted to highlight is Westenbrook versus Kappa Kappa Gamma. This is a sorority chapter at the University of Wyoming that admitted a transgender woman as a member. They decided that their bylaws, they were interpreting their bylaws to include as a woman trans women. They decided to make an inclusive step and interpret their bylaws in a way that was more inclusive. They were sued by some of their members that disagreed with that interpretation. And the court, again, really fell back on that Dale decision. They said that the organization has the ability and has the right, as part of its expressive association, to determine who its members are. And this piece here that I've boldened is a quote directly from this Kappa Kappa Gamma case at the district court level in Wyoming. I want to read it for you. Dale's takeaway for the court: the government may not defy the internal decision-making of a private organization, including the criteria governing that entity's membership. Whether excluding gay Scoutmasters in Dale or including transgender women in Kappa, this judge may not invade Kappa's sacrosanct associational right to engage in protective speech. Kappa's official position of admitting transgender women is speech, which this court may not impinge. So again, now we're seeing that connection very clearly between association and the governance of an association and free speech, and protected by the First Amendment. Next slide. So the status of this case, we're going to hopefully have something very, very soon. It's been accepted for appeal at the U.S. Court of Appeals for the 10th Circuit. Oral arguments are coming up just next week on May 14th. So I'm thinking that the next time Dorothy and I give this presentation, we will probably have an update on this. Essentially the plaintiff's complaint is that the sorority cannot admit trans women without amending their governing documents. That, just relying on interpretation is insufficient to, in their argument, alter the course of the organization. Kappa's motion to dismiss argued that they have a constitutional right to determine who to include and who to exclude from its membership. And again, heavily relying on that Boy Scouts of America versus Dale case that we saw applied in the 303 Creative case. Next slide, please. So, a couple takeaways, and this is sometimes a little bit difficult to see what the application is for associations, because we were talking about this a little bit in the abstract. So I want to give a couple examples, but it really starts with identifying what your expressive association is in order to protect your inclusive-oriented steps from being challenged. So you need to identify what it means to be a member. What is your mission statement? What is your, do you have a statement of principles? Do you have a statement of values that either as a profession or as a group say, this is who we are and this is what we strive to achieve? So it could be that, we seek to, promote the best professional practices and advance the profession and to promote diversity in our practice in our profession. That can be a very valid statement of your principles, and that's helping to define, who you are as an organization. It can also be somewhere in your code of ethics. These are not, people think of governing documents as being your articles of incorporation and your bylaws. These are both true, but that's not limited to just that. You can also have very foundational documents like your code of ethics, like your mission statement, like your strategic plan. These are all, helpful, documents that can bolster your identity and what you hope to achieve. But on the other side of that, you need to know what's in those formal governing documents, your articles of incorporation and your bylaws. Specifically, who has the authority to interpret them, who has the authority to amend them. It could be that you have an executive committee that gets to interpret bylaws. You may have a governance committee that does something like that. It may be related to your ethics enforcement of your code of ethics. Is there a committee that's convened? Are there certain members that decide on who to include or exclude or maybe kick out of your membership based on certain conduct? Who approves your policies and procedures? Is it just staff-based, or is there another committee of your board that considers these things as well? So it's not just the documents themselves, but knowing who gets the input into those governing documents. And the final thing is to ground your DEI initiatives in those governing documents, tying the expressive association to your actual governing practices. And the way that comes up is, how are you setting your membership criteria? Do your members have to have a certain number of years of professional experience? Do they have to have ownership of a practice or a business or some other kind of ownership there? Are they members of your board by virtue of their leadership positions in another organization, for example, a chapter or a region? These are all areas where we see a lot of clients trying to make adjustments to their governance to promote a more inclusive association. So, for example, requiring a certain number of years of experience, a certain educational level, a certain business ownership, tend to have the effects of excluding traditionally underrepresented communities. Either folks that may not have had access to education, maybe women who took time out of the workforce to raise children and don't have the requisite number of years of experience, or reinforcing the traditional kind of white-dominated leadership roles at chapter and regional organizations that filter through to another organization like a national board. So these are all things that associations are reconsidering to increase diversity and inclusion in their organizations. So those are the kinds of examples that are, very much tied to governance, and where a lot of organizations are trying to make those small changes here and there. So as long as you are able to pair that diversity initiative to your expressive association, the idea of what your organization is and hopes to achieve, you have a much better prospect for defending those kinds of governance models if you are challenged in court or otherwise. So, those are the biggest takeaways, and we hope to continue to get more clarification from courts, both on the kind of the contract areas that Dorothy was talking about, and also on and the difference between a contract and a contribution or a gift. But also on the governance side. And I think a lot of association professionals who are watching these cases are hopeful that these foundational cases that protect expressive association are going to continue to be upheld by the courts. So something we're watching very closely. That comes to the end of my part of the presentation. We do want to offer an opportunity for anyone to ask questions or give comments. So if there are any questions either in the chat, or feel free to come off mute, and Dorothy and I are happy to take questions at this time.
Well, real quick, there was a question that came in the chat kind of towards your last comment, and it's from Andrea, who may need to clarify, but I'll read it for her. So if the plaintiff wins, should we all look at our articles of incorporation and bylaws?
I'm not sure it's quite that simple. I think a lot of it's going to depend on, how the plaintiff wins and what the court is going to say about that Dale precedent. And I know what Dorothy was talking about is with all the settlements, we didn't have any clear statement of law. Right. This one is going to be argued through, at least through to appeal. It is also being supported by the appeals are being supported by organizations that, skew to the right and are very intent on pursuing appeals on kind of culturally divisive issues. And we expect that those appeals will continue. We don't expect this is going to be the last word on this. But it's not just going to be about who wins, it's going to be about how they win. So I'm sorry, I don't have a clear answer for you, but we want to see how the court treats that precedent to indicate what we may want to do next.
Well, I also want to add that people who are upset at you and upset at the programs and whatever, they're going to find a way to challenge you. It doesn't matter what the court says or this and that. It's going to be very creative, and when people are upset, they're upset, right? And so sometimes I ask, why did you ask the question? Well, you're asking the question because you want to minimize or mitigate legal risk. What I can say is, it doesn't matter how the court's going to rule in this case or that case in terms of your risk, because if your organization makes a decision and members or constituents or just random plaintiff groups targets you, you can't stop them, right? Because they're going to challenge you regardless, right? You can try to mitigate your risk, but you cannot eliminate people from suing you, because people sue everybody else all the time. That's why Kevin and I were in business, right? Because you can't stop people from challenging you in court.
Is there a difference between 501c3 and 501c6? Because we're a C6, which my understanding is it's more of a tradesman type organization. Does that offer any protection at all?
You mean, I don't see in terms of the content of our presentation, I do not think the C3, C4, C5, I don't see a material difference in terms of how it's applicable to. It's really looking at the program itself.
Okay.
And I think the core is you are a mission-driven, tax-exempt. The IRS approved your mission and therefore granted you your tax exemption status. That is a relevant part. As to what type of C, I don't think it makes a material difference for our presentation today.
Okay, thank you.
There was just a comment as it relates to Joy posted a couple of moments ago. I've seen some groups change the name from DEI to simply EI. Any thoughts on that?
Well, I think, or I can go first because I sort of saw articles that gets into that. And my view is it still goes to what the content is. What exactly is, what does the statement say? How do you phrase your purpose? How do you phrase your mission? How do you phrase your objective? You can call them different you can put a different name, but ultimately it's what are we trying to achieve? The description, the details, that's more important. I think there is a shift away from DE&I because it seemingly is getting a negative impression right now. So some people want to put the inclusion first. But again, if all you're doing is just changing the name of the program and not changing anything about the statement, objective, your mission, what you want to achieve, you're not changing any of it. You're just changing the name of the title of the program. I don't think that's going to do. I see why they're doing it, but you still need to look at the actual program itself. That's my opinion. So Kevin, you can.
Yeah, no, I think that's exactly right. I think I heard a DEI consultant addressing a client's board about a year ago, and they said something, they framed it in a way that really helped me kind of conceptualize a lot of DEI programs, that diversity is the input and inclusion is the output. Inclusion is what you get once you have diversity. So in that, with that kind of lens to it, when people think of diversity, it tends to, people tend to imply either, a quota system or, saying we need representation from all of these groups. But really, it's just the input. Your output isn't going to change. You still want to have an inclusive environment. And because that's a bit of a broader objective, like Dorothy was talking about, and a permissible one, then we just need to change the input a little bit to get to where we want to go. Again, because diversity tends to have a connotation of quotas and other things that the Supreme Court has said is probably not going to fly. So I get why they're making that change, so that they're not inadvertently implying that their program is doing something that they're not really doing. So I think it's a little bit symbolic, but it's important of the way the conversation is shifting in a way that's oriented towards legal compliance. So I think that just means that people are noticing these court cases. I think part of it is that is driven by fear. People don't want to get sued, but they're adapting to make sure that they can fortify their programs. And I think that's just one of the ways of doing it.
Well, we just have a couple of minutes left, and I think there's a pretty good wrap-up question there in the chat that I'll read out. We can kind of conclude with this final question. What general advice can you give to membership or associations who have and want to protect their grant and scholarship programs and their DEI resources and programs?
Well, I think there should be a review of what you want to achieve and your mission and how it relates together. My view is I do not think organizations should shy away from saying, okay, no DEI programs. That's also problematic too. But I do think it is a good time to really think about why you have these requirements. For example, I mean, any medical organization, I think it's a good example, is patients who have different skin color. You may be prone to different type of skin disease, right? Like exposure to the sun because of your skin color, it's different. A very pale skin versus a dark skin, the sun would impact the patient very differently. That's a fact. That's a medical fact. So therefore, for a skin doctor association, dermatologist, it is reasonable that they would encourage content or research and data, medical data based on skin color. I mean, that's completely reasonable. And you want to make sure all patients have really good medical information accessible to them, right? So you have to think about the why, and it's not really, my view is a lot of the program that I've seen, it's almost a copy and paste and just quote, historically underrepresented minority group. And if you're not, and it would be true for certain organizations. Some organization is based on heritage. Some organization is based on a specific religion. That is their mission purpose. That is different. But if your organization is more of a true professional without any of those, it's just one field and that field, there must be some kind of reason to support diversity. Again, diversity is not challenged. Everybody, there is agreement that diversity brings better viewpoint. but it's really the definition that should be reconsidered and revisited on your mission purpose. Like Kevin said, it's like, what is the association about? What do you want to promote? And we have a freedom to promote that because it's free speech. And then whether or not your program actually supports your mission, does it even make sense? And or are you just copying and pasting the historically underrepresented group? There's always more to diversity and inclusion instead of just copying everybody else's statement. So that is my my observation and suggestion.
Kevin, any final closing remarks?
I was going to say the exact same thing. I was going to refer back to what Dorothy had already said about, you know, making sure that it's not just a copy and paste job. I think that a lot of organizations have sometimes moved a little too quickly to project their DEI and diversity-oriented values. But in so doing, they may have not considered the impact of that language. So I think what a lot of groups should be looking towards is to, you know, examine that language carefully and make sure it fits their organization and isn't just cookie cutter. So exactly what Dorothy said.
Oh, wonderful. Well, thank you. I know I'm sure we could probably talk for another hour about this. Kevin and Dorothy, thank you kindly for your time today. Thank you, Jen and OVAMS, for your sponsorship. The recording and the slides will be emailed out later this afternoon. If you need anything from me or Calais AE, please don't hesitate to reach out. And otherwise, have a great rest of your day.
Thank you.
Thanks, everyone.